Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
Welcome back to More Law. Today we're discussing crime and punishment. And one thing we wanted to talk a little bit about is the difference between civil and criminal cases. And Don, you had a graphic, I think, that was going to help to explain some of that?
Yeah, you'll see the preponderance of the evidence is when I go to a jury, which I've done many times, on a civil case representing someone who's injured, we have to prove by a preponderance of the evidence. A preponderance of the evidence means probable. I've got to show that the facts, basically that it's probable that someone did something wrong, and it's probable my client was injured as a result of that, and what their probable damages were relating to that. Now, in a criminal case, it's different, and we'll let Rich explain that in just a sec. A really good example of this dichotomy was the O.J. Simpson case. O.J. Simpson was found not guilty under the more stringent criminal standard, which Rich will explain, but was found responsible or guilty under the civil standard, which is preponderance. Rich, tell us about the beyond reasonable doubt.
Sure, Don. In a criminal prosecution, before you can be convicted of a crime, the state must prove their case by evidence beyond a reasonable doubt. What that generally means is it's more than just more likely than not, as Don described, but preponderance. It's proof that you can rely and act upon in your most important affairs. You have to be firmly convinced of the truth of the charge before you can be convicted in a criminal case of any crime at all. So, for example, Don mentioned the O.J. Simpson case. O.J. Simpson was acquitted criminally because the proof was not beyond a reasonable doubt. Then a victim or victims in that case went ahead and sued O.J. Simpson. The burden of proof in that situation was beyond by a preponderance of the evidence, and they were able to prevail because there was probable cause, there was proof that was sufficient to meet the burden beyond a preponderance, but not proof beyond a reasonable doubt in that case. So it's not double jeopardy if somebody gets sued after they're acquitted in a criminal case.
No, how much, because I think none of us can escape the crime dramas these days, and you know, you just always hear people talking about what they saw and this evidence, but I mean, how much is that impacting the court systems? I've heard where, you know, jurors are trying their own experiments and prosecutors are finding it more difficult to prove their cases because people think they know what they're doing.
It's difficult in the age of technology for jurors to focus on the facts of the trial. We have Twitter and emails and all the media going on around a trial. Jurors are instructed to disregard any outside influences, not to conduct experiments, not to go on the internet during a trial, and avoid any outside contact that may have a bearing on the case they're hearing.
All right, well, let's hope they're doing that.
Hope so.
Come on now. Let's see, we do have Katrina in Mount Auburn. Katrina, you have an issue with your neighbor stealing your cable, is that right?
Yes.
Can you tell us a little bit more about your question for us?
I was calling to see who actually reported to, because I called Time Warner and I was thinking that they would come right out, and no one actually came out. And I called another number, and like I said, I guess it's nothing they could possibly do about it. But I'm going to call and tell them I'm not going to pay my bill because of that. The wire is actually running up to my neighbor's window, and you could pull up and actually see it. That she's stealing cable from me. They don't cut it before. When I had a technician come out, they cut the cord. He told me, like, your neighbor is stealing cable. I'm going to cut the wire now. Well, they doing it again, and they don't went in the box. This is the third time they don't actually went in that box.
Okay, let's see, Don, for Katrina.
Katrina, there's actually a couple of things you may potentially be able to do. One's civil, one's criminal. The criminal stuff you can't instigate with a private complaint. You have to talk to a police officer or a prosecutor or go down to the private complaint department, which Rich knows a lot more about than I do. The other thing you can do is, if this is costing you money, you could file a suit in small claims court. Chances are that's not going to get you very far, even though small claims court doesn't cost very much and is something you can do yourself. If a person is stealing your cable, especially if they're renting and they don't have a job or whatever, you can't collect from them, that's probably an exercise in futility. Going directly to the police might be your better bet. What do you think, Rich?
That's one option, Don. I think I would follow up with Time Warner. They don't want you paying for someone else's cable. I think they'll come out and check out the lines and make sure it's corrected and reimburse you for any costs that you've incurred. I would definitely follow up with Time Warner and stay on them until they respond.
I remember when there were only 3 TV stations. You had your CBS, your NBC, and your ABC. Fortunately, now we have Fox. Let's see, we have another caller, Natalie in Hamilton. Go ahead, Natalie.
Good morning. My boyfriend was recently convicted of possession of drugs, a minor misdemeanor, and he lost his driver's license, his CDL. The person who owned the drugs, which was potpourri, went to court, said it was theirs. My boyfriend was still convicted. He's lost his license now, and he's a CDL driver with no record at all. What can he do?
You know, with a CDL, that really ups the ante both for a DUI or for a number of different things, doesn't it?
Yes, it does. If he's lost his CDL, that's a real extreme consequence of that conviction. Did he have a trial, Natalie?
He did. He did not have an attorney because it was not a jailable offense. He couldn't get a public defender.
I would consult an attorney as soon as possible. You can see the ramifications of this conviction. Even though it was only a minor misdemeanor, it has a big effect on his livelihood. So I definitely consult an attorney.
Thank you very much.
One of the
Good luck, Natalie.
Sorry about that.
That's okay.
One of the things I think is important to point out is that a CDL is a commercial driver's license. So if you make your living driving and you get a DUI or you get something that causes you to lose that license, you got to find another way to make a living. That's the end of your job as a commercial driver.
Okay. We hope that is helpful, Natalie, and we are taking another break right now. Of course, we'll come back with more law, taking your calls live on Crime and Punishment. Stay with us. The Ohio and Kentucky Bar Associations require we give the names and addresses of the attorneys on the show, so here we go. Richard Goldberg is with Shue and Goldberg, 2662 Madison Road, Cincinnati, 45208. You can get in touch with them at 321-2662 or ShueGoldbergLaw.com. Don Moore, of course, 1060 Nimitzview Drive, Cincinnati, 45230, 232-2000 or morelaw.com, or you can find it all at Fox19.com. Now, we had spoken a little bit before the break. There was a caller who said her son did not get an attorney because it was something, whatever the offense was, it wasn't something he could go to jail for. But now it's really coming back, and he's having some real issues with his job. So let's talk about the fees and something being worth the payment based on your livelihood.
Well, that's exactly right. The fee business is at the top of people's mind when they need a lawyer, or they're worried about maybe should they get a lawyer or not get a lawyer. I'm a personal injury lawyer. I handle cases on a percentage basis, which means if I don't collect, I don't get paid, and the client doesn't have to pay anything. However, criminal lawyers it can't work that way for them, can it?
No, it cannot. In fact, it's not proper or ethical for a criminal lawyer to charge a contingent fee.
Right.
Certainly not based on the outcome of the case.
Exactly. So how much do criminal lawyers charge, and what's it going to cost somebody?
Well, we'll talk about that, something dear to my heart, attorney fees. Attorneys charge on a flat fee basis, depending on the type of case, the complexity of the case, and different lawyers charge different fees, of course. For misdemeanor cases, an OVI, for example, is a misdemeanor. The fee can range from several hundred dollars to several $1,000s or more on an OVI case. Again, it depends on whether or not the case ends up in a plea bargain, whether or not it ends up in a trial, or some kind of negotiated settlement. And as to felonies, which are more serious crimes, the fees easily run into the thousands typically, again, depending on the complexity, the skills of the attorney, the amount of time involved, and whether or not the case is going to go to trial or resolve itself short of a trial.
Well, let's go back to the phones now. We have several calls we're trying to get to before the end of the show. Let's first, Thomas in Fairfield. Thomas, you were pulled over for speeding, and you say you weren't speeding.
Yes, ma'am.
Okay, can you tell us about your interactions with the police at this point?
No, I either got an option. He told me I'd have to prove my speed. So I drive for a living also. I have a commercial driver's license.
So when they say that you'll have to prove your speed, how are you planning to do that, or what are they telling you need to do?
Well, that's what I'm saying. I don't have any computer in my truck for the company that I drive for to say how fast that I was going. I'm on my way to work. I drive that road 5 to 6 days a week.
Is there anything you
Every
would
day.
suggest that he might do, Don?
Thomas,
Rich?
Thomas, were you driving over the posted speed limit?
I was doing 58 in a 55-mile-an-hour zone.
Okay. And was traffic heavy or light or moderate?
No, it was real light. This is like 4 o'clock in the morning.
Well, despite the posted limit, then, it sounds like you were driving reasonably under the circumstances, and I think you should go to trial on that case and contest it, and the police officer and the prosecutor must prove that you drove excessively under the circumstances. So if 58 and 55 under those conditions was appropriate and reasonable, then you should be found not guilty.
One of the things that I think is important in a case like this, this man may have his livelihood riding depending on where he is. If you get a speeding ticket, you don't necessarily lose your CDL unless you've got a points problem or some other issue or become uninsurable. But my goodness, if it affects your employment and you're at that point, that's when you're really going to need help. And you get a balancing as to whether a person, is it financially worthwhile to hire a lawyer versus go do it on your own, because the fine for a speeding ticket typically is only $100 max. Isn't that right?
That's correct, but the ramifications could be substantial. And that's why it's important to seek professional consultation on something like that. An outcome typically could be perhaps there could be a plea negotiated to an equipment violation from speeding that would not interfere with his CDL.
We've talked about DUI a couple times, or driving while intoxicated. And how much does a driving while intoxicated cost beyond attorney's fees? We talked about those a minute ago,
Yes,
but
we
that's
have.
just the beginning.
That's just the attorney fees, and we're talking thousands of dollars. We're talking about increased insurance premiums for 3 years. We're talking about reinstatement fees, probation fees, fines, court costs, the cost of attending a driver intervention program, if that's part of it. These are hundreds and thousands of dollars by the time you're done with it, before you get to attorney fees even.
So you're talking like $3,000 to $5,000 probably minimum for a DUI if there's a conviction.
You very well can be, absolutely. Yeah. Absolutely.
Okay, great.
Okay, I think we have another call right now. I think we want to go to Roger in Cincinnati. Roger, I know you have a very serious question, but we only have about 2 minutes left in the show. Could you tell us, you believe you were framed by the police, is that right?
Well, actually, I know someone that was framed by the police. They used a confidential informant who had charges already pending against him. In order for his charges to be reduced or dropped, he had to turn over his supplier. Therefore, he framed someone that was innocent that had nothing to do with anything. This person has served the time now, and after serving the time, one of the officers involved, and who testified on the stand, has admitted to a felony crime themselves. So how can a person at this point prove their innocence when they've already served the time? I guess the statute of limitations as far as the appeals are concerned are out of...
Okay, I'm just going to stop you right there, Roger, because we just have about a minute to get to the answer here. So, Rich, what would you suggest?
Just quickly, it's really hard again, once a case is over and a conviction's been entered, to try to overturn something like that. If the appeal time is expired, I would say he's going to have a very difficult time doing anything about that at this point.
Don, did you have anything to add to that?
Well, actually, Rich handled that great, and I really appreciate you being here. I want to mention next week we talk about grandpa and the law. I want to say what that is. Basically, estate planning. What happens when a person can no longer take care of themselves? They need the help of their family to manage their business affairs. It's a really important show, and it's a big change up from what we've done so far.
Okay, thank you. Rich, thanks for joining us
Thank
today.
you.
We hope you'll come back.
I will. It's a pleasure to be here.
Thank you, and thank you for joining us. We'll be back here next Monday morning at 9:30 for more law. Have a great week.